the audience knowledge and enrich the knowledge as a whole. So with these words, let me introduce our eminent speaker, Advocate Dr. Gaurav Gupta. It is a very long list for the introductions. So 2 pages cover hona muskil hai, but I will try to few of the things I will cover. Advocate Gaurav Gupta is graduate from Sri Ram College. He is fellow member of the Institute of Chartered Accountant of India. He is ISA. He has obtained doctorate in taxation from Robert D. Sorbonne University of France. He is practicing as an advocate in Delhi High Court and Tax Tribunal. He is practicing as an advocate in the High Court, especially Delhi High Court, Tribunal, and other courts. He is having more than 18 years experience in indirect taxations, during which he was extensively involved in consulting and litigation of SSC, including multinationals and domestic companies across a range of sectors such as infrastructures, power sectors, medical, telecommunication, broadcasting, etc. He has also worked as a head taxation in the listed group and with a tier 1 consulting firm of indirect tax, and head worked in assignment involving provision of opinion and consulting to Fortune 500 companies. He is also author of the numerous books of GST, including Comprehensive Analysis of GST on Services, Goods and Service Tax Law and Practice, Handbook on GST, GST Manuals, GST References, Audit and Annual Returns in GST. He is also author on Service Tax Law and Practice, Service Tax Ready Reckoners. He has been a special invitee to the indirect tax of the ICAI in 2012, 14, 15, 17, 19, 2020, 23. He was co-chairman of Indirect Tax PhD Chambers of Commerce in 1920. He is the vice president of Celtics Bar Association Delhi for the financial year 23-24 and was a selected executive committee member for 2021-22 and a joint secretary for financial year 2014. He was a special invitee to National Executive Committee of All Indian Federation of the Tax Practitioners and member of the Indirect Tax Representation Committee of All India Federation of Tax Practitioners for the term 2022. He was also a co-opted member of the Strategic Prospective Planning and Monitoring Committee of ICI for the financial year 21-22. He has addressed more than 600 seminars on indirect tax in various forums, seminar, conferences organized by the professional bodies and associations, including PhD Chamber of Commerce, ICI, ICSI, Sale Tax Bar Associations, National Chamber of Commerce or Industry. He is also a faculty on GST and indirect tax organized by ICI, GST Commensurate. With these words, now for this important topic, I will hand over to our eminent speaker, Advocate Dr. Gaurav Gupta, for his deliberation.
Thank you, Anupji, for your kind words. At the outset, I thank the ACAE and the accompanying associations, including STAR, for arranging such a wonderful initiative. It has always been a yearly, yearly fiesta for all the members, and lead is usually taken by the very learned friend of mine, Tarunji, in arranging these particular sessions. So I hope the earlier sessions have been useful, and this particular session I'll be also able to add some value to the learning of the members. So with permission of Tarunji and Anupji, I'm starting my deliberation, sir. Friends, topic for today, the very sensitive topic which has been kept for today is arrest and summons. We all know when we hear these two particular words, there is definitely a sensation in the mind of the listener, leave apart the person who is facing such particular consequences. These are two words which are often being used now in GST. Earlier, they used to be very rare a phenomena in taxation laws, specifically in the indirect taxes. But in the last 2-3 years, we have seen an increase, or rather the summon has become a inseparable part of any investigation and arrests, as we have seen. So the country has witnessed more than 300 arrests in GST. The numbers have increased over the period of time. Now, we definitely need to ponder on the reason for such grave consequences which have arisen out of a tax law. It is a tax law. It's a civil consequence. It's no criminal offense. But with time, the definition of the criminal offenses have also been expanded, because maybe earlier only a physical infliction might be a criminal offense. Gradually, the mental infliction, other offenses came into place. Economic offense took a very prominent place down the line. More and more judgments we have seen are there which are recognizing of economic offenses as one of the very grave offenses, because in economic offenses you will find that they are not an offense against a particular individual, that is an offense which is against the entire society. Now, when you are committing an offense against the entire society, you're basically also infringing the fundamental rights of many other people. So when you're speaking about an economic offense, you have to be very, very careful. You have to be very, very sensitive, because this is transgressing into the life and liberty, and also the resources which are attributable to the society at large, is available to other individual, but have been misappropriated, have been sort of fraudulently evaded by a person. It is very common to quote the very celebrated judgment of Y.S. Jagan Mohan Reddy versus CBI. It is a 2013 Supreme Court decision. The Honorable Supreme Court observed that economic offenses are now a class apart, and they need to be visited with a different approach in the matter of bail. When we will speak about arrest, we will definitely speak about bail also. The economic offense, they have deep-rooted conspiracies, and they involve huge loss of public fund, which need to be viewed seriously. Now, consider the gravity which the Honorable Supreme Court has given to economic offenses. And therefore, it is considered as grave offense affecting the economy of the country as a whole, and thereby posing serious threat. As I just spoke, that if you're into economic offenses, even the fundamental rights of other fellow citizens are inflicted in such particular cases. So you're not inflicting a particular person, maybe the entire society at a large. So while granting a bail in those particular cases, which are economic offenses, the court will have to keep in mind the nature of accusations, the nature of evidences, the severity of punishment which conviction will entail, the character of accused, circumstances which are peculiar to the accused, reasonable possibility of securing the presence, and reasonable apprehension of the witness being tampered. Now, some of the aspects are common, but in the entire judgment, what we find that the gravity or the seriousness which has been given to the economic offenses have brought them to a class apart from other criminal offenses. And therefore, in GST, when we speak about GST, when we speak about arrest in GST, my dear friends, you will find that these particular offenses being economic offenses, and economic offense towards state. Now, state fund is a public fund. It's a public money. So any person who is sort of doing a fraud against the state is actually inflicting or is damaging the money which was supposed to be attributed to masses at large. And therefore, the seriousness increases. At the outset, let me also discuss one very important aspect. All of my friends are aware that there is one section 69, the other is section 132. While 132 talks about a conviction of the punishment which is there under the on certain offenses where a person can be convicted in GST, section 69 is speaking about the arrest. Now, which of them is more serious? In the past, all of us are aware that the arrests which have happened under section 69. They have not happened under conviction under 132. Please understand this one particular point. 132 will happen once your investigation is over, your charges are made, your adjudication is over, and your adjudication, after your adjudication, you have been convicted. Thereafter, the punishment under 132 will be effected. But under 69, the conviction is not necessary. It is during the investigation where the officer, the proper officer feels, the other riders are there, we'll go into that later, that a person need to be detained. There, the power is given to the commissioner to be exercised in a very sensitive manner as why the liberty of a particular person should be taken away and he should be detained. So GST being an economic offense, we have found that courts have not been easily granting bails in such particular offenses, and the state has been very sensitive in moving the arrest in the cases, and therefore it has become very tough in the past to get bail in these particular cases because the kind of evidences, the kind of trail which the state has is actually the homework is very detailed, which makes it tough for the person who is the detentive to actually come out of that particular scenario. So my dear friends, let us first speak about section 69. Section 69, let me read out before you. The order is order to arrest, where the commissioner has a reason to believe that a person has committed any specific offense. Now, the key word is reason to believe. Here, the conviction is not happening. It is merely on the reason to believe. When you read section 132, the offense is established. The conviction is established. And therefore, the difference between 69 and 132 is primarily on account of the reason to believe and the establishment of the offense. In 69, the offense is yet not established. The person who is convicted is not the person who the person who is arrested is yet not convicted, but the commissioner under this particular section has to have a very strong reason to believe. Reason to believe what? That the person has committed any offense under clause 1, A, B, C, or D of section 132, of which is punishable under subsection 2, 1, subclause 1 and 2. And he authorized any officer of central tax to arrest such particular person. So, my dear friends, the reason to believe is not a sort of a fiction. It has to be based on very cognate reasons. You need to have proper proof. It has to be properly documented. A reasoned order as to why this particular power is exercised has to be put in records before this particular exercise is undertaken by the tax authorities. Now, the reason to believe is again a serious word. The question then comes up is, who can be arrested? Then the answer again is the person who has committed the offense under subsection 1 of 132 A, B, C, and D. Now, my dear friends, all of you know that section 132, subsection 1, 1, clause A, B, C, D. These are 4 very serious offenses in GST. And what are those? Let me read out. Number 1, supply any goods or services without issue of any invoice in violation of the provision of the Act. Meaning thereby a person is without issuing the invoice with the intent not to pay the taxes, is supplying goods and services, but ultimately no tax will be paid to the government. B, issue any invoice or bill without supply of goods or services, or both in violation of the provision of this Act or the rules made thereunder, leading to wrongful availment or utilization of ITC or refund of tax. Now, this particular case is dealing with you are issuing an invoice without a supply of goods. The first one was supplying without invoice. Second one is issuing an invoice without supply. Now, this is where when we speak about clause B is basically what we know as fake invoices. Invoices where there are no underlying supply of goods or services, which are baseless, which are fictitious. Number C, the third offense, A, B, C, avails ITC using the invoices referred to in B, or fraudulently avails ITC without any invoice or bill. So, on the basis of these fake invoices or only the paper document, if somebody avails the ITC, or for that matter, he fraudulently avails ITC when he does not have any document in terms of a proper tax invoice, That is covered by C. And last but not the least, the D collects any amount but as tax, but fails to pay to the government beyond a period of 3 months from the date on which such payment becomes due. My dear friend, this is again a sort of a deterrent that you cannot collect any amount as tax. Maybe you are making a non-taxable supply, but if you have collected any amount as tax, you cannot pocket that. So for example, I'll give you a very small example on that particular account. A person was supplying services and he was supplying exempt service. Or let us take a very simple example. A person is supplying agricultural produce. Now that particular gentleman who is supplying agricultural produce has been issuing invoices where he is charging amount and tax at the rate of 5%. Now this particular gentleman who is issuing such particular invoices knows that it is an exempt supply, and tomorrow the officers come and he's able to establish that I'm making an exempt supply. Yet, my dear sir, since he has collected an amount which he has represented as tax in his invoice, that particular amount, whether or not it was supposed to be paid to the government, will be paid to the government because it has been collected as tax. And therefore, such particular amount was, if not paid beyond a period of 3 months from the date when such particular amount was supposed to be paid, it may entail to a punishment which is under 132 and also a consequence under section 69. Now, 132 will take its own time. Meanwhile, the commissioner feels that during the investigation, he has reason to believe that this particular person has committed an offense under section 132, subsection 1, and either of the 4 clauses. Then he can order any subordinate officer to arrest such particular person. It is very interesting to note that 132(1) earlier was only limited to whoever commits. The provision has now been amended to include the person. Now this was from 2021. Whoever commits or causes to commit and retains a benefit arising out of. So there are 2 conditions. Number 1, the person who is effectively committing, meaning thereby the person who is issuing the invoices, who is taking the ITC, or for that matter, making a supply without invoices. The person who is committing the offense. And who will be that person? If we understand in common parlance, that person will be the person who will be the proprietor of that particular firm. Now, there are 2 cases which come before all of us. Whether that particular proprietor is aware that these particular action has been done on his behalf. So meaning thereby, he is not aware that his PAN has been used fraudulently by another person to issue such kinds of invoices on such particular PAN. Now, my dear sir, in this particular case, there are 2 offenses which has happened. Number 1, which is a fraudulent, which is a fraud against a person whose PAN is used for taking the GST registration and issuance of invoices under that particular GST. And number 2, the person who is actually issuing the invoices. Now, please understand and appreciate, whoever commits, in my humble opinion, the latter person who is issuing the invoices will be covered into this particular scenario, while the first person who is not aware that such particular action has been taken on his PAN by taking a fraudulent number and issuing invoices will not be covered under 132(1)(b). He should, as a matter of fact, should also file an FIR for misuse of his PAN with the respective state, police authorities. So this is one particular angle which everybody has to keep in mind. Second, an angle which comes is a person who causes to commit and retain the benefit. Now, this is very interesting a category. Now, what is the meaning of causes to commit? Now, this gentleman has not committed this offense, but he is causing the commission of an offense. What is the causing of commission of an offense? It can include, number 1, inducement. It can include, number 2, assistance. It can include, for the very matter, a sort of a channelization or being a conduit to that particular offense. So through him also the invoices may have gone, and he is aware of such particular, the fake invoicing or the ineligible ITC being passed to a particular person in which he is also a party or he is also a sort of a intermediary in that particular commission of an offense. So three words which I'm using is: number one, he is inducing; number two, assisting; and number three, he is an intermediary. All the three persons can be included within the very purview of causing to commit that particular offense. And the second condition which need to be fulfilled to attach 132 to this particular person is he should retain benefits arising out of such particular commissioning of the offense. If he has merely induced, so suppose somebody has suggested to a friend, why don't you start the business of fake invoicing? But he merely gave an advice and he went away. Now, this is a mere statement which he may have made out of a simple statement or a joke or whatever. But that person will not be committed under 132 because he has not retained the benefit arising out of that particular commissioning of the offense. So in order to establish or to implicate any person under 132 under this particular category, both the aspects: number one, causing to commit, that need to be established. Number two, that person also need to be shown that he has retained the benefits arising out of. Now, my dear friend, this is an accusation. Please remember. And in this particular case, it will not be the onus on the person uh, uh, who is the respondent to establish that he has not got any benefit. Rather, it will be the onus of the state to establish that he is a person who has caused it to commit this particular offense and also has retained the benefit, any amount of benefit. No amount has been prescribed, but any amount of benefit arising out of this particular offense. So these particular four offenses and these two categories of people can be convicted under 132, or for that matter, they will be covered under the arrest provisions under section 69. That they will be, if the commissioner has reason to believe that this person has committed or caused to commit and retain benefits, then commissioner has a power to ask a subordinate officer, authorize him that this particular person be arrested under section 69 of the CGST Act. Now, once a person is arrested, then there are certain duties casted on the officer. It is not that the person has been arrested. The person under 69(2) will be, who has been arrested, shall inform the person of the grounds of arrest and produce him before a magistrate within 24 hours. Now, at the time of arrest, why the person is being arrested? Number one, very clear grounds have to be told to him. Number two, a close kin relative of that particular person need to be informed that this particular person is being arrested. And number three, the arrest memo should also be shown to that particular person. Number four, within 24 hours of such particular arrest, he has to be produced before the magistrate. Now, please understand, there are instances where a person has been called to give a statement under a summon, under an investigation, and that proceedings have been followed by the arrest. Now, the time frame of that 24 hours will only start when the person has been arrested and not from the time when he has been summoned. So please try to distinguish these two particular clauses. It is also imperative for the officers to produce that particular person within 24 hours. They cannot legally detain a person beyond 24 hours if they fail to produce such particular person before the magistrate. Also, my dear friends, please note that under subsection 3 of section 69, subject to the provisions of CRPC, where a person is arrested for any offense under the 4 subsection 132, he shall be admitted to bail or in default of bail forwarded to the custody of the magistrate. Now, once a person has been arrested and he will be produced before the magistrate, the officer will have to then produce the memo, what has to be done with this detainee. Now, this particular memo will seek the custody, or they will seek the judicial custody of this particular person for the purpose of continuing a fair investigation. Now, we all know it has been a tried law that bail is a right, the arrest is an exception. The detention will be an exception. Why it has been said so? Because ultimately any arrest, the person is yet not convicted. It's not a punishment, but he is detained during the investigation. So basically during the investigation, when he has yet not been convicted, somebody is devoided of his liberty, of his freedom. And therefore, this particular fundamental right, when you are taking away from any person, the offense or the establishment of the offense should be very, very near, should be very, very certain, should be very clear, unambiguous. It should not be a suspicion. No arrest can happen merely on the basis of a suspicion. And second, in case of a non-cognizable and bailable offense, the deputy commissioner or the assistant commissioner shall, for the purpose of releasing the arrested person on bail, have the same power and be subjected to the same provision as the officer in charge of a police station. So as the power has been given to a police officer, in case of a bailable offense, the DC and AC can exercise this power and they can release a person by following the procedure as provided in CRPC. Now, usually what we have seen is once the arrest has happened, we have not come across a case where this particular subclause B of subsection 3 of 69 has been exercised and AC and DC have used their power to release the arrested person. Often the government will, I'll not say often, but in very exceptional cases, the arrest has happened in bailable offenses. My dear friend, it has also been argued many a times that since the maximum conviction under the GST statute, the GST statute, our friends, we are also you're putting some questions in the chat box. So, Kavinji, I'm taking your question as of now because I can only see one question. If the amount received as tax are paid back to the customer through credit note, otherwise, then whether the same will tantamount to 132(1)(d. My dear sir, in 132(1)(d, Kavinji, it is not merely a collection. It also need to be retained. If you have refunded back, so collect any amount as tax but fail to pay to the government beyond 3 months. So if you have refunded back that particular amount, then that particular amount cannot be said to be collected. Any action, so it is very trite a law in case of ITC also. If you have availed an ITC but you reversed, there are plethora of cases where the Honorable Court has said that in such particular cases it will be deemed that as if no ITC has been taken. So same case will be applicable in 132(1)(d) as well. So in case of 132(1)(c), a person might have taken a credit inadvertently. So there was a totaling error of, let's say, 1 CR. But the very next month, he got to know that this error has been committed and he deposited that amount. My dear sir, in that particular case, there will be no conviction, there will be no arrest, because that particular person who has availed a ITC without invoice has reversed the action suo moto when he came across the issue. But I will also put a word of caution here. There are people who have been using the ITC column in the return. Now, this has actually reduced in the last 1 year when the government has started highlighting the ITC box in 3B as red if you're availing more credit than what is shown in GSTR 2B. But prior to that, and very knowingly, some people today also maybe, they are using this as a tool of working capital management. How they are using it? They avail the ITC knowing that this particular month I don't have a cash flow, but I will have a cash flow next month. So they avail the ITC and in the next month they reverse ITC and they pay from the bank. I would definitely put a word of caution, my dear friend, in these particular cases. Your action, if it is a repeated action, can be seen as a tool of tax evasion by the government as being falling under 132(1)(c). So my humble suggestion would be that no person should be using taxes as a tool of work, managing the working capital. Earlier, you must have heard people saying, sir, government is charging less rate of interest than the bank. So with the time, the government has increased the rate of tax to as high as 18%, while the banking interest, I don't think that much have increased. So now the deterrent in terms of using such particular tool is also in terms of the rate of interest. But still, if anybody is continuing with that kind of a practice, and if it is established that it is a known, or it is the person has done it knowingly, the person can definitely be in a deep problem. Now, coming back to 69, I have talked about 69, the power of the commissioner, the responsibility of the officer who is arresting should produce. Now, and we have also spoken on the offenses. Now, in terms of certain instructions, which has been released by government in by way of instruction number 2 by 202223, certain guidelines have also been given as when to make an arrest. Well, the first and the most important guideline which has been given is that the reason to believe to arrive at a decision to place a alleged offender under arrest must be unambiguous and amply clear. If you are still in doubt that that person may or may not. So, for example, if the officer is reviewing or is examining a case and he finds that the rate of tax is 5%, while the person has paid the tax as 5%, while the correct rate is 18%, can such particular person be covered under any of the provisions of 132(1)(a) to D? No, sir. Those particular cases do not fall. When there is a ambiguity as to the rate of tax, that cannot be said to fall under A, B, C, or D, because the person has not supplied without invoice, he has not made a invoice without goods, he has not availed a wrong ITC, and number 4, he has not collected a tax which he fails to pay to the government. So none of the 4 cases are covered in those particular cases. That cannot form the basis of arrest even though the amount exceeds 5 CR. So that is the first point. The allegation under the 4 clauses must be established unambiguous, meaning thereby the offense of issuing fake invoices. Now, how that is established usually, the source in terms of where those particular invoices initiate is tracked. Number 2, the government also looks into the investigating officers goes to the premises of the supplier, which they found as non-existing. And number 3, then they look into the kingpin, the person who is behind, who is the mastermind of the entire, what do you call that, the racket or the fake invoice chain. And that particular person will be taken into custody by the officer once it is established that he was in possession of creditable evidences which established that he was the person who was the initiating point for those particular invoices. Now, after 2021, even the persons who are sorry, causing such an offense will also be placed into such a certain bracket. Now, another question which comes up, which is being examined, I would say, is does the GST officers have a power to arrest? Now, this is one particular question which is sub judice in the case of Sapna Jain, and more importantly, the Honorable Supreme Court has taken up a larger set of questions for consideration arising from the judgment of Telangana High Court. The questions which have been framed are, number 1, now this is in relation to Customs Act, but they will definitely be having a great implication in GST as well. Whether a DRI officer is a proper officer for the purpose of Section 28 of the Custom Act. Number 2, whether the summon issued by DRI officer to respond under 108 of the Custom Act could be said to be without jurisdiction. Number 3, now these are very important for the very simple reason that in Canon India, a DRI officer was not held as not the proper officer for making the reassessment, and therefore the show cause notice was quashed by the Honorable Supreme Court in the earlier verdict in the case of Canon India. Whether the DRI officers are police officers and therefore are required to register FIR in respect of offense under 133 to 135 respectively of the Customs Act. Now, my dear friends, this is very, very important a question. If a person has been granted, if an officer has been granted the right to arrest someone, he also should be casted with the responsibility to file an FIR. FIR is a very sacrosanct record of the information, and therefore it has a grave, or it has a huge, I would say, importance in the criminal offenses. So the third question which is put before the Honorable Supreme Court is whether they are police officers and they need to register the FIR or not. Number four, whether the provision of 154 to 157 and 173 of the CRPC would apply to the proceedings under the Customs Act in view of Section 4.2 of the Code. And last question which is posed is whether in respect of the offences under 133 to 135 of the Customs Act, the registration of FIR is mandatory before the person is arrested. Now, these particular questions are before the Honorable Supreme Court and will be settled over the period of time. Meanwhile, while the arrests are happening in the GST Act, or for that matter, the Customs Act, the officers are not considered as police officers. Rather, in the earlier Supreme Court decisions, when you're talking about the statement, it is a trite law that a statement given before a police officer is not maintainable or admissible as evidence before the court. However, that is not the case with the Customs Act, or for the matter of GST Act. Any statement given, because these are considered as not to be police officers, and therefore statement given before them, they hold a evidential value. They hold a evidential value in the court of law. Now, this is paramount. Evidence Act also plays a paramount role in determining the admissibility, of the statement in the proceedings. Now, coming back. So when we were looking in the instructions, we spoke about how the officers, are they police officers or not. It is also very important. Very recently, Honorable Supreme Court in one of the ED matters held that any authority which has a right to arrest has also the right to seek custody. Now, this is very, very important in light of all these kinds of offenses and in these kinds of actions which are, or the powers which are given under the statute to the officers. My dear friend, please also note that many of the high courts, while talking about the arrest, the power to arrest, have also upheld that GST is a self-contained code and it does not need to draw its power from the IPC, and therefore the arrest can happen under GST statute also. Now, having been given these kinds of power, it was very important to make a SOP which came by way of the instruction number 2/202223, whereby the when and how those particular powers are to be used was told, and therefore the questions which were to be answered by the learned authority before deciding the arrest have been listed as follows. Number one, whether the person who was concerned in the non-bailable offense or with the credible information or a reasonable suspicion exists of his being so concerned in the crime. So that's the first question which need to be answered by the learned authority. Please understand, the word is creditable. Credible information should be in place. If it is merely a suspicion, then the word which has been used before suspicion is reasonable suspicion. Now, I would like to mention here that while the first case where there is a credible information will be a safer zone for arrest, a reasonable suspicion when no credible information is there will not be a good act of taking away the liberty of a person. Number two, whether arrest is necessary to ensure proper investigation of the offense. If the person is not arrested, will the investigation go in the same manner? So, for example, the wife of a director who is not very active in the business, but being a director, she is one of the persons who can be arrested because she is a part of that, or she falls within the persons who can be convicted in terms of offense, or for that matter, a partner who is the wife or in the part of the partner who is a partner in the partnership firm. So Mr. X is a partner, his wife who is not very active, and both of them run the partnership firm. Now, this particular lady, she is not very, very active in the business. Can she be arrested Now, her arrest will not ensure a proper investigation. Rather, Mr. X, his arrest is necessary to ensure proper investigation. And therefore, if the action is taken on the other side, it may not be the correct action as per the SOP. Whether the person, if not restricted, is likely to temper the future course or furtherance of the investigation. How much evidences can be collected from him or from other sources, and can such particular person tamper with the evidence? This is again a very serious check which need to be seen by the learned officer and later by the courts. Please know, this is a tried established law. It is a tried established law. In case of any arrest, when the bail is being considered, three activities or three actions which can be alleged on the offender. If any of the three offenses or the three actions can be proved or can be established towards the offender or the conspirator, the bail will not be granted by the court. The three being: number one, the custodial investigation is necessary. If the state can establish that custodial investigation is necessary, merely giving someone, this person coming, will not help in the investigation, bail will not be granted. Number two, a heinous crime is involved. Now, this will be only established if the quantum is big enough. Now, how will the quantum will be established? Please also appreciate the magistrate at that particular point will not be looking into each and every document of how the computation has been made. But on a very prima facie level, the examination or the observation is to be placed before the magistrate that this particular amount or this particular gravity is there in the case, and why this particular person then therefore should be not granted the bail. Number three, possibility of influencing the witness. If the person is in a position to influence the business, or four, if he can tamper the evidence, bail will not be granted, and rather the arrest will be the correct procedure or the process in such particular cases. Fifth, whether the person is a mastermind or the key operator affecting proxy or those particular transaction, which we call as fake invoices, paperless transaction, paper transactions in name of dummy GST or non-existent person, for passing the fraudulent ITC. Now, this is a very easy to understand kind of a concept, that this particular person is not the proprietor, but he has used the fraudulent PANs of other people to generate fake entities and issue invoices therefrom. So is he the mastermind or the key operator doing such particular thing? We have also seen in the past that the arrests are not merely restricted to such particular key operator or the mastermind. They also go to the conduits where the volume is very heavy on those particular conduits or intermediary. Last, whether the person has committed or caused to commit an offense under 132(1)(c). Now, 132(1)(c) is a graver offense, for the very simple reason, the person who has issued the invoice. Now, why 132(1)(c) is seen as a graver offense? If I am issuing an invoice which is fake, right? The person who is issuing the invoice is not supplying any goods, so he is not supposed to pay any taxes. He will be issuing invoice and he will not be paying, suppose, the tax to the government. He was not supposed to pay the tax to the government. If he is merely issuing invoice, not paying tax to the government, that is one offense which is not going to the detriment of the government treasury. What is going to the detriment of the government treasury is that invoice is being used by a person who is supposed to pay legitimate tax to the government. He is using that particular invoice to reduce his payable amount to the government, and therefore that particular fake invoice which he is using, barring the argument that even though those taxes have been paid to the government by such particular person, this gentleman is supposed to not take the credit of those particular invoices and pay the correct taxes to the government. Let me give you a very small example on this. Mr. X is a businessman. He has a monthly liability, let us say, of 3 crore rupees. Now, this particular gentleman need to pay 3 crore in cash or by debiting the cash ledger to the government. Now, this gentleman, what he does is he uh, gets some fake invoices. He pays the amount to that particular gentleman. Tell me one thing very frankly. If he is paying 18% correctly to that gentleman who is supplying the fake invoicing, will this person ever take that particular invoice? No, sir. He will not take. Because there is no incentive for him to take up fake invoice. When does the incentive come? When the supplying person is giving him the invoices at 4, 5, 6, 7%, or maybe half the rate what he is supposed to pay to that particular person. If he is paying the full rate and full amount, then there is no incentive for this person to take. He will better pay to the government directly. Now, knowingly, this gentleman knows I'm getting an undue advantage from the other person. He is taking those particular invoices and reducing the liability which is supposed to pay to the government. Therefore, 132(1)(c) is seen as a graver offense by the government. The persons who are also calling for such particular invoices, who are the buyers of these kinds of invoices, are also a big, I would say, catalyst or a big demand creator for suppliers to come into the market. So government wants to determine. So this is one of the reasons which have been put in the instructions to be seen. Now, we have seen the section 69, the arrest power, the precautions to be exercised, the right of the person to be produced before the authority. Now, question comes about the bail. Supreme Court, in the very celebrated judgment of Joginder Kumar versus State of UP, emphasized that simply because police has power to make an arrest does not mean that the arrest should be made. Now, with this spirit only, that particular instruction number 2 was taken out by the government. Given the paramountcy of the liberty in our constitutional scheme, because life and liberty has been given as a fundamental right to every person, the power to arrest should be exercised only as a necessity, as an extreme, as not a regular, as an exception. So that is why the maxim says that bail is a right, but arrest is a exception. Similarly, in 1997, 98, the Supreme Court, again in the case of very celebrated case of D.K. Basu versus State of Bengal, West Bengal, issued a continuous mandamus on the mode and manner of arrest. A detailed literature you can find in that particular decision. I would now read one very interesting decision for you, which was in the case of Arnesh Kumar versus State of Bihar. Allow me to read what Honorable Supreme Court said in that particular case. It is a very recent case, 2014. Before a magistrate authorizes detention under Section 167 CRPC, he has first said to be satisfied that the arrest made is legal in accordance with law and all the constitutional rights of the person arrested is satisfied. If the arrest effected by the police officer does not satisfy the requirement of the section of the code, then magistrate is duty bound not to authorize his further detention and release the accused. In other words, when an accused is produced before the magistrate, the police officer effecting the arrest is required to furnish to the magistrate the facts, the reason, the conclusion for arrest, and magistrate in turn should be satisfied that condition precedent for arrest has been satisfied, and it is only thereafter that he will authorize the detention of the accused. Now, my dear friends, this is very serious observations from the apex court of the country. Arrest power is a huge power, and with huge power we all understand that the responsibility level also increases. Again, I'll read out para 7.1 of another decision from the Honorable Apex Court. It is evident that a person accused of an offence punishable with an imprisonment for a term not less than 7 years, or which may extend to 7 years with or without fine, cannot be arrested by a police officer only on satisfaction that person has committed the offence. A police officer before arrest, in such cases, has to be further satisfied that such arrest is necessary to prevent such person from committing further offense. Now, these are equally applicable in GST also. Please understand. So, what are the conditions has been laid down by the Apex Court? That police officer should be satisfied that such arrest is necessary to prevent the person from committing further offense, or for proper investigation of the case, or to prevent the accused from causing evidence to disappear, or tampering with such evidence in any manner, or to prevent such person from making inducement, threat, promise to any witness so as dissuade him from disclosing the correct facts to the court or the police officer, or unless such accused is arrested, his presence in the court whenever required cannot be ensured, meaning thereby that person can abscond. In these circumstances, the bail should not be granted by the magistrate, and rather, if these cases, if these situations are pre-answered, looked into by the authorities itself, then it becomes a very easy case for the magistrate to allow the detention of that particular person and upheld the arrest of such particular person. In pith and core, the police officer before arrest, or the GST officer before arrest, must question himself: why arrest? Is it really required? What purpose will it serve in this particular investigation? Will it give him the requisite object? It is only these questions, when they are addressed and one of those conditions are enumerated above, are satisfied, the power to arrest need to be exercised. In fine, before arrest, the officer should have reason to believe, on basis of information and material, that the accused has committed the offense. So it is not merely the commissioning of the offense, the conditions which circumference these particular the requirement of arrest are also very, very important. What we always focus on is that the person might tomorrow be upheld, his conviction might be upheld, but my dear sir, arrest is not a power which is a conviction. Arrest is a power to, I'll again in bold and underline, arrest is a power to be exercised to ensure a free and fair investigation by the police officer, or for that matter, the tax officer, since these powers have now been entrusted to tax officer. In one case, now this is also a very interesting case. I'll read out the observations of Honorable Apex Court. In case of Siddharth versus State of UP, instructive words are extracted in instruction number 2 of 2022, which I just spoke of. The Honorable Apex Court said, we may note that personal liberty is an important aspect of our constitutional mandate. The occasion to arrest an accused during investigation arises when custodial investigation becomes necessary, or when it is a heinous crime, or where there is a possibility of influencing the witness or accused may abscond. Merely because an arrest can be made because it is lawful does not mandate that the arrest will be made. A distinction should be made between the existence of the power to arrest and justification. Now, these are very important words. A distinction must be made between the existence of the power to arrest and justification of exercising such power. If arrest is made routine, it can cause incalculable harm to the reputation and self-esteem of a person. Very rightly placed by the Honorable Court, the sensitivity to the physical, mental, and the social health of a person has been rightly captured in the decision of Siddharth versus State of UP, in answering the gravity of why the arrest is such a sensitive topic and to be exercised with such a caution. Friends, many other decisions, they spell out the same spirit. One very interesting decision which came up in the tax regime was Make My Trip India Private Limited. It was a case of straight arrest, which was when the case came up before Honorable Supreme Court. It was a case of service tax evasion. The observation of the Honorable Apex Court was, before making the arrest, department must adjudicate demand and also grant hearing to the SSC as to material collected. Now, The regime is different. The clauses were different. But why this particular observation was made? Because that particular the allegations were premature and they were not falling in one of the four cases which we have discussed under section 132. It was a demand case. Unless that demand was established, it was not one case where the tax was collected and pocketed. It was not a case of it may be a case of wrong payment of tax, but not tax collected, not paid, or for that matter of issuance of invoice without supply or without service. And also in case of habitual tax evader, arrest may be made straight away, but subject to review of the past conduct and only after recording prima facie view as how the assessee is a habitual tax evader. In these particular cases, in this particular case, the Honorable Supreme Court, sort of directed the authorities, please also look into the conduct of the past of a person before you make a arrest. Also, for making the arrest, it was to be determined that some degree of clarity, certainty, that the person has collected service tax but failed to pay to the government should be there. So as I just said, that was not a case of 139(1)(d). It was a demand which was not adjudicated, but was supposed that yes, huge demand may be there against this particular person. And the importance of creditable material, you can definitely find in the case of Make My Trip of Honorable Supreme Court. PV Ramanna Reddy is another decision which we cannot skip when we are speaking of arrest. Supreme Court upheld the decision of Honorable Telangana High Court, which rejected challenge to the power of issuing summon under GST and held that the person can be arrested in cases of GST evasion. So the arrest by the GST authorities was upheld in this particular decision. If even before the GST regime is put on track, someone can exploit the law. This was the observation of Honorable High Court in the case of PV Ramanna Reddy. And without the actual purchase or sale, the raise of claims of ITC to the tune of 2.5 CR is what alarmed the entire system and moved the court to allow arrest in these particular cases. Now, please also understand the conduct of some of the assessee. They will not be more than one person in the entire system, not even 1%. I might be saying 0.201%. The conduct of 0.01% in the entire system, which might have affected the conduct of 8 to 10% of the entire GST ecosystem stakeholders. Why I'm saying 8 to 10%, while the person issuing the fake invoices will not be more than 0.1%, but the persons who are claiming the ITC in the entire chain will be to the tune of 8 to 10%, that is for sure. The quantums will vary, and therefore one has to be very, very sensitive, as while he is not the kingpin or the generator or originator, but he also being a beneficiary of such particular, I would say, the public offense, evasion of tax, he will have to be aware of the consequences arising from such particular action. So GST has seen a huge government dent which is made on account of these fake invoices, and therefore we have seen that courts have not been kind to grant bail in these particular cases where the quantums are very, very high to the so-called accused in those cases. Now, in GST officer arrest, again, the matter is sub judice in terms of the power to arrest by the GST officer. Sapna Jan, we all know. Having said that, in case of arrest and bail, it is very, very important to also understand that power to punish set out in 132 would only stand triggered once it is established that the offense has been committed. And that has to necessarily be post determination of demand due from the assessee. So first there will be an investigation, then there will be a show cause notice, then there is a adjudication, then there is a determination of a demand, and thereafter the stage comes when prosecution under 132 can be effected against a particular person. So kindly please make a very clear distinction between 69 arrest and 130. Now, I think having spoken enough on arrest and bail, I would now like to turn the topic to summon. I have a lot more to say on arrest and bail, but I can now flip my notes and I'll now come to the second topic of the day, which is summon. Sir, arrest and bail are more serious an offense, but summon, even though that is not an offense, that is not even an allegation of an offense, but that particular one document, it definitely brings goosebump to the person receiving the document. That's summon. Now, what is a summon? Now, summon is a power to call or call in person, any person whose attendance is required as necessary either. Now, please note very, very carefully the requirements of Section 70. When can a summon be issued? Either to give evidence or to produce a document or any other thing in any inquiry. Now, summons are not merely for giving a statement. Why summon has to be issued? For two reasons, which has been captured very, very clearly in unambiguous manner in Section 70. Number one, when the officer considers that it is necessary for that person to be present to give evidence. Number two, now that evidence can also be in the way of a corroboration. When you say corroboration, that means that there will be some fact which will be presented, which he will be affirming or confirming before the officer. Only his opinion recorded in the statement will be no evidence. So, for example, an employee statement of an employee is taken against a proprietor that is your employer engaged in fake invoicing. The employee in his statement may record that considering the number of dinners which my proprietor has in particular month in 5 stars, it is not possible that this can happen without issuance of a fake invoice under the system. Sir, no proof, no evidence. This is not what Section 70 is supposed to do. It will be either to give a evidence or, for that matter, produce a document. So there are documents which, if required from any person, will be listed in the summon that you are supposed to be present along with the following documents on a particular date at a particular time in the particular premises as mentioned in the summon before the undersigning authority. Now, the power to issue the summon has been given to the superintendent in case of a GST. Please also note that every inquiry which is under Section 70 subsection 1 shall be deemed to be judicial proceeding within the meaning of Section 193 and Section 228 to 228 of IPC. Now, these particular sections have been borrowed from IPC in order to ensure the effectiveness of the summon. What does 193 of IPC says? Whoever intentionally, the word is intentionally, knowingly, in full senses, gives false statement in any of the judicial proceedings, which this statement or summon is deemed to be a judicial proceeding, or fabricates false evidence for the purpose of being used in any stage of the judicial proceeding, shall be punished with the imprisonment of either description for a term which may extend up to 7 years, and shall also be liable to fine. And whoever intentionally gives or fabricates false evidence in any other case shall be punished with the imprisonment of either the description of a term not extending 3 years, which may extend to 3 years, and shall also be liable to fine. In one's own case, 7 years. In somebody else's case, 3 years. Similarly, 228 ensures that there is no insult or interruption happens to the public servant. So whenever any person intentionally insults or causes any interruption to any public servant, which such public servant is sitting in any stage of judicial proceeding, then such person who is causing such particular insult or interruption will may be punished with the imprisonment extending up to 6 months or a fine of up to rupees 1,000 or with both. So these two sections have been borrowed from IPC, uh, uh, set along with section 70 to give it the real fangs or to give it the real protection, so that they become effective. The summons become effective. Now, the word summon when in GST, how and when it is to be used. What will happen if someone does not follow this summon? Set aside the implications in GST, which might be merely to for some amount. The real implication arises out of section 174 and 175 of IPC, which provides for punishment for non-attendance in obedience to an order from a public servant when he is calling you under a summon. If you're not obeying, then you may be punished with a simple imprisonment for a term which may extend to 1 month or a fine as prescribed. Similarly, 175 of the IPC, the person is, when there is a omission to produce a document or electronic record to a public servant by legally bound to produce it, then in that particular case, if it is not complied, then again that particular act is punishable by an imprisonment, simple imprisonment extended up to 1 month or an fine of rupees 500. So looking into the gravity of the summon, the powers which can be enforced both under the GST and the IPC, summons have often been used in a casual manner by the authorities. And understanding this particular aspect, the government again came out with the instruction number 3 by 2023, 2223, whereby very clear instructions are issued as to when and how the summons should be issued by the officer. Now, under instruction number 3 by 202223, it has been laid down that the exercise of the power to issue summon is done judicially and with due consideration. It is not to be done in a hayward manner or in a casual manner. The officer should use it as a tool to drive his investigation in a proper manner, effective manner, and not just to sort of enforce his power to the assessee. Second, officers also are advised to explore instances where instead of reporting to someone, a letter of information, requisiting information may be called. So it is because the letter of requisition of information may not be replied or complied by the taxpayer, then resort may be taken to summons. Summons should also be taken. Now, this is also very important to understand that even though the power to issue the summon has been granted to the superintendent, but this particular power has to be exercised only after obtaining prior permission from an officer not below the rank of deputy or assistant commissioner, with reason for issuance of summon to be recorded in writing. Though we don't go into these particular aspects, but if necessary, this is one of the part of the instruction. If such particular instruction cannot be obtained since the person who is the senior officer, deputy or assistant commissioner is not available, then in that particular case, such particular permission in writing can be taken once that person is in office. Meanwhile, before the issuance on summon, the telephonic or the verbal approval should be taken from the superior officer. The officer who is issuing someone should also record in files about the appearance or non-appearance or the compliance of the summon, and should also place a statement which has been recorded in file. Please also note that someone should normally indicate the name of the offender against whom the case is being investigated. Meaning thereby, if a person is getting a summon, he should know in which case is the summon being issued. If the summon does not state about, then the person is not aware as to why he is being called, and therefore he may not be in a position to effectively participate in the proceedings at the time when he is called for the summon. Issuance of a summon may also be avoided to call upon statutory documents which are already available on the portal. So officer can simply pull them. For merely getting the GST returns, one may not issue a summon to the company or the concerned officer. Senior management such as the CMD, MD, CEO, CFO, all or the PSU officers should not be generally issued summon in the first instance. So in one of the instances, a very senior high official of a multinational company was issued summon. Thereafter, after a huge hue and cry and representation, the instructions were issued in the excise days, and similar instructions have been followed today as well, that senior management should not be called upon in the first instance itself. You please proceed to first issue the demand for documents. If not complied, the first officer, and later on, if he does not also comply, then you go to the senior management. Also, attention has been invited in the instruction to the earlier board circulars where the requirement of quoting DIN, I think the board circular number 122 oblique 41 of 2019, whereafter the DIN has been made mandatory on all communication. Now, please note that this particular DIN is mandatory only in case of central officers. It is not mandatory in case of state officers, because state has not yet complied with, or he has not issued a system of issuing DIN on the documents. Once summoned, I've already told you that the person is duty bound to appear before the officer, comply with the requisites in the summon. If he is in possession of those particular documents, then he need to produce those particular documents before the officers, otherwise not. Now, please also appreciate that while the duty has been casted on the officer to use his power judiciously, it is also the duty of the taxpayer to comply with such particular instructions seriously. If the documents are being called, those documents need to be submitted. If he is called upon to sort of give any statement or evidence, he should produce himself and give the requisite, whatever available with him. Now, we have also often found that many show cause notices have been issued merely on the basis of statements. Now, this has been a recent trend in case of fake invoicing, because there is a lot of vacuum in terms of creditable information. The only information one gets is in the form of an invoice, a paper invoice. But behind that, the requisite, the evidence. Now, what are the requisite evidence, sir? The requisite evidence will be in form of the electronic system which has been used to generate the person who has operated, the person who has signed, the person who has delivered. All those documents are very, very important. The filing of the return, the IP address which has been recorded. Now, when you look into the show cause notices, all these corroborative or the underlying evidences are often ignored by the investigating authority. There is a long, I would say the road is long on both sides. The department and the association all have to learn a lot from this. The officers have been issuing show cause notices, making parties to numerous persons in the entire chain, issuing a common show cause notice. That common show cause notice, there is a very specific notification number 2/2022 central text, whereby centralized power has been given to certain additional commissioners who can adjudicate show cause notices across India. So DGGI, who is already in having the all India jurisdiction, now shares the all India jurisdiction to adjudicate those show cause notices with these specified officers in that particular notification. And that particular notification, very interestingly, it is introducing a clause 3A in the erstwhile notification, whereby it starts with a non-obstinate clause, notwithstanding the powers conferred under the clause 3. Now, that is overriding, because clause 3 talks about a particular jurisdiction. An officer of a particular state will have a particular jurisdiction. 3A speaks about the powers overriding the jurisdiction, and there is where it is considering the power to be all India power. Now the question is whether that particular kind of power can it be given, and more particularly looking into section 6 of the GST statute, where the sharing of the power between the center and the state officer have been listed. My dear sir, this particular question, whether any central tax officer, DGGI, I am not going into, but yes, DGGI will, once other officers, the question is settled, DGGI will also be questioned later. But the question of whether can any authority have a all India jurisdiction in GST regime is one question which is tested across forums, is sub judice, more particularly for the very simple reason that one state authority cannot have a all India jurisdiction. So a parallel power with the central authorities, is it possible? Just because the central tax is a single act for the entire nation, can the central tax officer under the powers given under section 6 subsection 2, let me read out that for you. Section 6 is authorization of officers of state tax or union tax as proper officer in certain circumstances. Parallel or pari passu provision also is there in State Tax Act, subject to the conditions specified in the notification issued under subsection 1, which is providing the jurisdiction and powers. Where any proper officer issues an order under this act, he shall also issue an order under the state GST or UT GST as authorized by the state GST or UT GST Act, as a case may be, under intimation to the jurisdictional officer of the state or union territory. Where a professor, subclause B, where a proper officer of the state under the state GST or the UT GST has initiated any proceeding on a subject matter, no proceeding shall be initiated by the proper officer under this act on the same subject matter. Now, this is one thing which I was wanting to discuss. The power under the restriction on the power of an officer to initiate a fresh proceeding when a state authority has already initiated the power, or for that matter, center has initiated, then state will be abstained from exercising that particular power. But before that, the officer, when he is issuing an order under CGST, is also duty bound to issue the order under SGST. There will be no separate order under the SGST. Under the powers given, that particular power is borrowed. Now, can an officer sitting in Ahmedabad obtain the power to issue an order on behalf of a tax officer sitting in Bihar, state tax officer? Now, that is one question which need to be understood. Was the spirit of sharing the power was in such a manner that center can enjoy the all India jurisdiction while the state cannot? Now, more importantly, why I am saying so, the entire chain, the hierarchy of the courts having jurisdiction also is determined by the person issuing the order. So if the order is issued by the additional commissioner of Central Tax Ahmedabad for a person having a jurisdiction in Bihar, the cause of action is sitting in Bihar, the authority exercising power is sitting in Ahmedabad, and now the question will come up. Now, this is one question which has already been there in income tax in case of faceless assessment. In that particular case, because it is faceless, the Honorable Court has held that both the both the courts have a jurisdiction on such particular cases. In this particular case, it will become a very tough decision because writ jurisdiction is one thing, but when you're going into a appellate jurisdiction, whether the Ahmedabad tribunal or for that matter the Bihar tribunal will have the power to adjudicate. More particularly, the Ahmedabad tribunal will then get a power to adjudicate the Bihar GST also. So please understand, when you are talking about any authority which is framed at a national level under the CGST Act, all the higher authorities under that particular chain will also get a all India jurisdiction in such particular cases. Very sensitive an issue. I think the courts will definitely provide very soon the decision on these particular aspects. the spirit of GST, whether it is one nation, one tax for central officers, but not for state officer. Number two, the chain of jurisdiction of the higher courts in case of a national authority under central tax. These questions will definitely come up before us in the coming times. The decisions will be before us. Now, let me share some very important decisions with you on the summon. As I just spoke of 6.2b, please take note of a very important decision. TVL Al Madina Steel Traders versus Superintendent or the intelligence officer. If the state authorities have initiated the proceedings against a taxpayer and the subject matter is same, please note, if the subject matter is different, then proceedings can be initiated separately. So there was a set of fake invoices which central tax officer was investigating. The state officer got information in respect of a second set of fake invoices. In such particular cases, another proceedings can be initiated. But if the subject matter is same, the central authorities will have to necessarily drop the proceedings if the proceedings are first initiated by the state authorities. So this was in TVL Al Madina Steel Traders versus Superintendent. In case of Kamlesh Majita versus AC of Sale Tax, this is a Bombay High Court decision wherein the Honorable Court held that person who is not a proprietor of a concern involved in fake ITC can still be summoned to inquire about the involvement of the person in the alleged scam. So question was, if there is a person who is not the proprietor of the fake invoicing, but can he be summoned? Now that power under section 70 is not restricted only to the accused. It can also summon other people for accumulating or assimilating the information or evidences, or for also inquiring the involvement of such other person in the entire alleged so-called scam. In the case of Shri Balaji Associates versus State of Andhra Pradesh, it was again an Andhra Pradesh High Court decision. The Honorable High Court said someone directing customers of the petitioner not to make the payment to the petitioner are illegal and therefore liable to be quashed. So officer exercising his power not merely called the person who is the customer of the petitioner, he also instructing him, do not make any payment to the petitioner, even though he's a supplier to you, till the undersigned give you a clearance. The superintendent gives you a clearance. That particular summon was also quashed by the Honorable High Court because these kinds of instructions cannot be given under the summon. So, friends, I think now it is time to take up some questions. Anupji?
Yes, sir. Yes, sir.
Yes, sir. Sir, the topics are very vast and it has been
Yes,
time.
yes.
It's a webinar, not a seminar. So I
Correct,
think
correct.
it is now time that we take up some question if the learned friends have.
Yes, sir. Let me check the first chat box if any questions here. Is this answered? Okay. Okay. Now the audience, if you have any kind of questions on the today topics, you can ask, and accordingly I can unmute also. Sir, Osik Nahar. Yes. Yeah.
Sir, in case of summons, if suppose 3 summons are issued and the assessee does not appear before the department, is it that the department either has a right to search post summons or they can issue a warrant to be present before the department against that summons?
Kaushikji, we must appreciate that summon itself is a warrant because it is the powers which have been given under section 70, as I just spoke. The specific inclusion of section 70 subsection 2 gives the power or gives the fangs to the summon, and they will be deemed to be judicial proceedings.
Okay.
So as I already spoke, that 174, 175 of IPC will be triggered against a person who is not in compliance, and he may be imprisoned also for non-compliance of summon. So those are grave consequences. But yes, if you speak about these particular proceedings leading to a proceeding under 67 in terms of search, I don't think so, because you don't need a summon to initiate that. You can simply do it.
Yeah. Because
It is
many times
it's a game of mindset, not power. Oh, this person is not coming for 4 times.
that's perfectly pointed out. It's a game of mindset, because many times we go to the officer
Correct.
within someone's दे दिया है, नहीं तो फिर मैं search करता हूँ. So that was just running in my mind.
But believe
I
me,
think that's clear.
there are senior officers, and usually in very rare case this may happen, that a person, because of his ego or mindset, can undertake such an action. There is a very set system where searches cannot happen in this particular case. It is better, I always say, comply with all kinds of summon and judicial proceedings. It is the duty of the assessee. And yes, there will definitely be some tabs on the power of the officers, as we have spoken in many cases.
Fine. Thank you.
Yes, sir. One question in the chat box. Can the copy of statement given during the summon proceeding be obtained from the proper officer? If yes, from where the power to seek such information comes?
Aditya ji, that particular power is listed nowhere. However, please also understand and appreciate the statement which you have given during a proceeding, that can, the copy of any document, it is not something which is seized. It is part of the proceedings, can be called upon by the person who has the power to so-called call the file or the proceedings from such particular officer. Now that particular thing can only be called if you have a power to investigate the file of the officer. Second, at the end, if that particular statement is relied upon by the officer, that particular statement will always form RUD, relied upon document, in against such or in such particular show cause notice. So that statement will definitely travel to you if it is being relied upon by the officer and made part of his investigation, resulting or accumulating into a particular demand. So in my humble opinion, we definitely will get investigations and trials. You have to keep it apart. While in investigation, there is a assimilation of information. The investigation of file power is restricted. Once it is a stage of trial, which we know as adjudication, the inspection of those particular papers and documents can be done anytime during the adjudication period.
Any other question from the audience? Sir, actually, under section, just as you said, under section 69, the commissioner has reason to believe. The reason to believe was a key word quoted under section 69 of CGST Act. So can the taxpayer exercise their right to request reason to believe from the concerned officer?
See, that particular thing has already been laid down in many of the decisions. This is no new term. This was one term which was in income tax also, but over the period of time, the things have matured. Reason to believe cannot be questioned by the person, but that again, we also have to keep in mind the courts can anytime summon the file to be presented as to what were the reasons to believe to initiate such particular action. So it is not very easy to officer that without recording cognizant reason, he can undertake a particular action. So that particular power, the courts can summon, the person cannot challenge at that particular point of time.
Sir, next question from Mr. Aditya Singhania. Can an authorized representative appear in the summon where summon does not mention any specific name, designation of the taxpayer entity? Is it suggestible to attend summon by the AR? Your views, please, sir.
whether I would say that if a someone does not provide even a designation. So it has been said that if the name is not available, at least the designation or the person you are wanting, his designation should be given in the summon. A summon in to a company is effectively no summon. So while we can take such a position that yes, such a particular summon is no summon, I would still suggest that you comply in terms of writing back to the officer that this summon does not name, does not provide the requisite list of information, and therefore it is not possible for us to comply with this particular summon. You are requested to kindly list out the requisites which you are seeking from the company. So through AR, now it is a very good question from Aditya ji, and I'm putting this to thought of everyone, a simple thought to everyone. It has been seen that ARs have been authorized representatives have gone to address the summon on behalf of proprietor, partners, directors, etc. While you may, but if it is a statement in terms of producing the documents, you may. But summons require the personal presence of the person whose name is there on the summon. So that cannot be replaced. That can be comforted. That can be comforted in terms of officer allowing the production of documents of information through an AR. But please, no AR should give any statement on behalf as representative of the person who is being summoned. I'm putting in very clear words. You are no person to give a statement. You can appear in a proceeding. You can represent in a proceeding, but you cannot become the person at any stage, and therefore you cannot record a statement before the officer on behalf of such particular person.
Thank you, sir.
Arupda ka ek question hai.
Acha. Arupda, please. Yeah.
Gaurav, Mike, how are you?
All good, sir. All good.
My question is that, now say a search is happening and then, there is a seizure and then suddenly there is a derivation that there is a loss to the revenue of amount, say 10 crores. And an arrest is happening without any kind of assessment or something like that on the day or say within 2 days of the search. So how far that is legally valid? That is one thing. And second thing is whether in GST, are we seeing that, anticipatory bails will be common in the days to come?
Arupda, you have not been with us in my deliberation.
No, I have been there.
I answered this very, very sensitively when I was drawing the distinction between 132 and 69. 132 will be the determination of the liability and then conviction. But
Right.
69 is a power given to the commissioner to ensure fair and free investigation.
Right.
If a person is in a position that he can influence the witness, tamper with the evidence, make the evidence go, and the person is the commissioner has a reason to believe that this person is the person who has committed the offense or has cause to commit the offense after 2021.
Yes.
Only in that particular case, even without determination of a complete amount, without adjudication, arrest can happen. Conviction will happen later.
Later on. Because here the arrests are being made.
Here the key word which has been used in this section is reason to believe. Reason to believe.
Right.
Now, reason to believe is a word where there is no surety. It is a considerable suspicion which has to be accompanied by cognate or reliable information. That is the key word. If that can be established by the state, arrest can happen. It can happen in 2 hours. It can happen in 2 years. No time period.
Right. And in this case, can the accountant, who is just passing on the accounts, can he be treated to consider that, he is carrying out?
Unfortunately, while the power of arrest has been given under GST, under 69, now what does it say? Reason to believe that the person has committed or
Abated.
cause to commit.
Yes.
Or any of the offenses under 139(1) A, B, C, D.
Right.
The question whether this one person who is the accountant falls within that is usually not appreciated by the judicial authorities because they are not looking into while granting bail. They are not looking into section 69 per se, but the grant of bail as a larger criminal CRPC proceedings. And therefore, we are not able to get respite on those particular grounds. Same, the fate has happened with the chartered accountants also. So please understand and appreciate the drawing or the power which has been drawn from 69. It is very restricted provision. The law is yet to be laid. A different set of bail law need to be laid for 69, which right now is not there. And this law will develop over a period of time because this is a new law. Unfortunately, we are sitting right now on a section to arrest under GST. But when we speak about bail, we go on to the general judicial precedents. And therefore, we don't get so good a respite or a particular respite, I would say, under GST in such particular cases. So the battle is long. We all have to insist the judges to look into the limitation. It is not an open-handed power as IPC. It is a very restricted power to arrest which has been given. And if the person is not falling within that particular power, that very the linking of that person with the crime is so apparent that he does not get that sentiment from the judge. Usually that is the case. So if it is a case of an accountant, then accountant need to be the beneficiary. If it is established, then he will not get that benefit from the magistrate. So maybe over the period we will see 69, either it is being laid as a complete law when the cases will travel to Supreme Court for bail, which is right now not the position.
No.
So let them travel to Honorable Supreme Court, then you will find a law which will be laid down for 69 bail separately.
Thank you.
Right, sir. Sir, we have another question from Mr. Surjit Sarkar. Non-lawyer, non-CA GST practitioner can appear before appellate authority and tribunal.
Sir, is it a question or is it a statement? I don't know. But it is not correct.
Any other questions?
So I think Tarunji, with your permission, we can put rest to today's session.
Yes, sir. One more question, sir. Under section 69, any time limit for the exercising section 69?
No. I just told no time limit. 2 hours,
No time.
2 years or 20 years. No time.
No time limit.
The only limitation is terms of adjudication, which is under 73 and 74. Within
Right,
3 years and 5 years.
Correct, sir. Correct.
Adjudicate, close.
Tarun, yes.
Yes, Gauravji, I think we had a very wonderful deliberation on this very important topic. And it was also very heartening to see that the participants were asking questions and discussing things. So if Anup, if we don't have any other question, then we can maybe close it for the day today.
Yes, Tarun, because we have covered all the questions, right? So we can close accordingly. So,
can you please give the formal vote of thanks?
Yes. Thanks, sir.
So looking into July, I am thankful to every person who has taken out time to be with us. It is always indeed a pleasure to be a part of this deliberation, the yearly fiesta of ACAE. And, as a representative from Society for Tax Analysis and Research, it is always our privilege also to be a part of this annual fiesta of ACAE. And we hope that under the very good leadership of the society, you all will be keep on organizing this year on year. Tarunji, let's try to make it offline next time. Thank you to all the participants present, sir. Thank you, sir.
Thank you, Gauravji. Thank you, Tarun. On behalf of the ACA, I would like to extend vote of thanks to our esteemed speaker, Gauravji. Gauravji has covered this session, excellent session, we can say, and also interactive because of the theoretical and the vast topic he has excellently covered. So this as quoted by the Gauravji, under section 69 and 132, there is a major one difference. Section 69 can be exercised during the course of the investigation, but 132 can only be exercised when offense is established. Meaning there are when investigation is over. This is the major difference between under section 69 and 132. The insight and knowledge shared by the sir have undoubtedly broadened our understanding of the legal aspects surrounding summon, arrest, and bail within the context of the legal regulations. Thank you very much, sir, for excellent and interactive sessions. Thank you very much. On behalf of the ACA, now, sir, memento we are sharing.
Thank you, sir. Thank you.
Thank you, Gauravji, and we are also thankful to STAR for being an associate partner organization in organizing this wonderful GST certificate course. We always look forward to your participation and your organization's participation in these programs.
Always, it's our pleasure, sir. Always.
Thank you so much.
Thank you.
Thank you.
We also thank all the participants for joining in today. We are leaving you a little early today, but we'll again meet tomorrow at 5 o'clock with another speaker and another important topic. Thank you so much. Thank you, Anu.
Thank you, Tarun. Thank you, Gauravji. Thank you very much.